Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utility Subcommittee. Today is Tuesday, March 26, 2024. I'd like to call this meeting to order. Mr. Clerk, can you take the roll, please?
Representative Alexander. Representative Burkhart. Representative Clemens. Representative Freeman. Representative Hale. Representative Holsclaw. Representative Johnson. Representative Marsh. Representative Thompson. Representative Vaughn. Representative Vital. Representative Zachary. Chairman.
Here.
Chairman, you have a quorum.
Thank you, Mr. Clark. Members, do we have any personal orders before we get started today? If not, let's go ahead and we actually don't have any housekeeping. We just have a calendar with one bill on it, and that is item number 1, House Bill 2925 by Chairman Vaughn. We have a motion. We have a second. Chairman Vaughn, you are recognized, and I'll show a couple of amendments. Which one are you going to adopt today?
Thank you, Mr. Chairman. We're going to adopt drafting code 017323.
Okay, we have a motion and we have a second. Members, we are voting to adopt amendment drafting code 17323. All in favor say aye.
Aye.
All opposed say no. The ayes have it. Sir, your bill is amended. You recognize for explanation.
Thank you, Mr. Chairman. You've heard, many of you have heard ad nauseum me talk about the cost of, we always talk about trying to drive more affordable housing, yet we never stop to consider the price of the regulatory impacts that we place upon developers. This bill, I'm co-sponsoring with Speaker Sexton. It does two things. Number one is it provides an exception, a permissive exception to building codes. Right now, under building code, only apartments buildings can only go 3 stories on a single staircase. What this bill will allow is one to go to 6 stories on a single staircase, but it's capped at 24 units, basically 4 corner units stacked up 6 stories. This would allow for a little bit more apartment on less floor, less ground space. But again, this is a permissive bill. What we're doing is we're passing a fire code exception that local communities can adopt in concert with their own fire protection services. This just provides them the avenue by which they can do that if they so choose. The second part of the bill has to do with off-site expansion of utilities. And what we've seen across the state is there's varying degrees to which utilities have policies with regards to off-site extensions. In other words, some may say that, hey, if you extend this a certain distance, you may be reimbursed for it if it's a certain size. Others don't ever contemplate that and tell the developer, hey, you're going to install what we want you to install because that's what we want. What this bill does is it requires communities to basically, when you think about it, you've talked about all the different utility jurisdictions that we come across our state. This will present basically where people understand the rules of the road whenever they come into contact with these off-site extensions. And it will also level the playing field to some degree because some users may not be as sophisticated. If we have somebody that's doing their first time investment in real property, they may not understand that what's negotiable and what's not. This will allow jurisdictions to go in, set their reimbursement policies or their fee-based policies for whatever it is with regards to off-site sewer extension. Well, I say sewer. That's the one I'm most familiar with. Utility extensions to where people will know on the front end what they're getting into. And so that's what the essence of this bill and what it does. Again, the first part is permissive for local governments to adopt if they would like. The second is establishing a standard by which off-site utility extensions are managed in dealing with governments and developments. And what this will do is it'll help standardize the practice, even though there's a large number of jurisdictions involved. And I'll stand for any questions, Mr. Chairman.
Chairman Vaughn, what I'd like to do is we've got somebody here that wants to testify. Let's go out of session, hear from them, go back in session. We'll let folks ask you questions.
Sounds great.
Right. Members, we are going out of session, and I'd like to invite up Mr. David Windrow with the Tennessee Fire Chiefs Association. You can have a seat wherever you like. Mr. Windrow, and a couple of things. Just you have 3 minutes once you get started, and just make sure that that little red light is on and state your name for the record. You're recognized.
Yes, David Windrow, Fire Chief in Nolensville, Tennessee. I have about 40 years of experience. all these codes, and I'm cognizant trying to find affordable housing, defining that, especially in the urban areas. Costs are out of control. We're building a fire station. Believe me, I know. But codes were based on catastrophic events that happened in the past, and we want to be careful not to repeat those. That's where the codes, you can always tie an event to it. Starting in 1911 with the Triangle Shirtwaist Fire, 111 died. Coconut Grove, 492 in Boston. Station Inn in Connecticut, 100. Even the two nursing home fires in Tennessee in the last couple of decades, 16 died in Nashville, 16 died in Johnson. It's usually an egress problem. The smoke is a problem, but it's also an egress problem. And obviously, from a firefighter's perspective, the most catastrophic, what we learned in 9/11 is people coming down and people trying to go up. One stairwell is going to really complicate, even if it's 4 units, and let's say it's lower than the average. Most homes have 3.8 to 4.2 people. If we say 3, there's 72 people trying to come out the door that the firefighters, the 20, are trying to go up. It's just a complication that we would like to avoid. Again, I understand the cost factor, but these codes have happened because of, again, catastrophic events through the years. The Beverly Hills Supper Club in Covington, Kentucky. On top of the fires were the egress problems and the lack of exits. And my 40 years experience tells me, and I've seen it in North Carolina, Colorado, other states, it's permissive this year. But once the bill's in, the door's open, then it's easy to change it from may to shall. That's the next move that we've seen through the years. And I've been chairing the legislative committee for the fire chiefs for 10 years. So that's the next ask. That doesn't mean you all approve it. The other thing in Tennessee, we were number 3 in leading the country in deaths for years. With the work of this body as a whole and the state fire marshal's office, we moved to number 9. I would like to get to 20 on fire deaths. And the cities that these affordable housings are the most vulnerable in the state. 130 people have died in Memphis in home fires in the last 9 years, and 57 in Davidson County. So it's problematic. We're going to weaken the codes in the most vulnerable areas that already lead. Memphis is leading the nation in fire deaths. And obviously that is our opposition, and I'll leave it at that unless you have questions. Again, and to put this in a sewer bill kind of caught us off guard.
All right. Well, Mr. Windrow, if you'll hang out, stay right there. We may have some questions for you. Members of the committee, you've heard from Mr. Windrow. Do you have any questions? Does anybody have anything? All right. Well, we appreciate your time. Members, without objection, we're going back in session, and we are back on the bill as amended. Do we have any questions for the sponsor of the bill? Speaker Marsh, you recognize.
Thank you, Mr. Chairman. And Chairman Vaughn, if you already have approved policies on how the utility and the builders work on this, this is not mandatory that they change anything. It's just saying, what is it actually saying? It's saying that they have to pay out of the subdivision to the utility main line, or they can pay, or they don't have to pay.
Chairman Vaughn, you recognize.
What it does, Speaker Marsh, is that it says that has to be an opportunity for cost recovery for system improvement that extends beyond what it is that they're putting in. Let's say that if I'm having to run a sewer line a mile to get to my property, then that sewer line will obviously across undeveloped property. Well, as that other developed property comes online, then there needs to be a mechanism by how the installer recoups that money. It doesn't say that, hey, I want to get my subdivision approved and it's a mile away from your service area, municipality or utility district. And so therefore you have to extend sewer to my property. But what it does say is that I have the right, that if I install it for you, if that's part of your planned sewer expansion and I put it in on my dime, that as other people connect to it, there'll be reimbursement available to me for building your system for you. And that's the premise behind this, is that everybody should pay their own way, but if you're paying someone else's way, then you should be able to recoup that money.
Speaker, you're recognized.
Will it be in an upfront contract? It says that. Who determines it? Who's the boss in this?
Chairman Vaughn.
Well, in those cases, everyone has sewer development, or again, that's the one I'm familiar with. Sorry, y'all. A utility development agreement with the provider that sets up the terms of what they're going to be putting in, the construction methods, the specifications for it. And so that's what it is. As a matter of fact, this bill was in a lot different shape when we had it last week, but in the week's time, this is starting to look a lot like what the jurisdictions that I work in do anyway. This is kind of the way that they work. I'll give you an example. In our case, we had a long sewer outfall that we were installing, and the city came back in and said, hey, we know that you only need this, but if you will extend it down into this distance and increase it from a 16-inch to a 24-inch, we will pay you the difference in that pipe because it's going to serve another industrial area. What this prevents utilities from saying is, hey, if you don't want to run it over there, well, you need to take care of some of our needs first that don't have anything to do with you, but we need you to do this or we're not going to approve your service. And so what we're trying to do is balance the playing field again, not only from the financial wherewithal of the people wanting to do this, but also from the sophisticated, some people may have done 40 deals and they've worked in various jurisdictions and have negotiated contracts with different municipalities. Or if you're a first timer, you may just say, well, that's the way things are done. Wow, I can't afford to do that, and nothing happens. And so that's what we're trying to do, is set up the guardrails for people to get in line with regards to these off-site sewers so that they don't prevent someone from building something, or either they don't change the economics to where the price tag of the product gets beyond what it needs to be for that type of product.
Speaker Marsh.
Thank you, Mr. Chairman. Is it mandated that the utilities serve your development?
Chairman Vaughn.
If you're building a subdivision and you're a mile away, is it mandated that the sewer provider hook to your project? And even though you're paying it, or can they tell you, we're just not going to do it?
Chairman Vaughn.
Thank you, sir. Well, in that case, I would assume that you would have a case to bring to the utility board that we set up last year on appeal, that we can go to these people to hear these grievances. And that's another part of this bill, is the fact that we can bypass people if they feel like they're being unjust. They don't have to file suit. What they can do is they can appeal to the board that we set up here last year, and them and the utility come in before this board that's made up of utility providers and find out whether or not they're being treated fairly or not, and in concert with the guidelines that we set up.
Speaker
Thank you.
Marsh.
Thank you.
Representative Alexander, you recognized.
Chairman, I've been meaning to talk to you about this bill. Of course, firemen in my area don't like the fire part of it, the building part with the 6 stories. Have we seen any other states go from 3 to 6, or was there a reason we didn't go from 3 to 4? It just seems like a lot of people in one building with one staircase. And is there anything in this bill that says if you do that, you would need to have like fire ladders, outside the building? Is there anything that says that to protect these people?
Chairman Vaughn, you recognized.
Well, we're talking about it over a microphone now.
I'm sorry.
No. Well, if you think about it, number one, regardless of the chief's position on the matter, this is a permissive bill. So if his local folks want to adopt it, then I would say that would be where to have this discussion. That's
Not here.
and not
Okay.
here. But again, the product that we're talking about, in most cases, on 3 stories, you can have travel distances way beyond what these are, because what we're talking about is a 6 stack of quads. And so you've got 4 corner units so the travel distance to the stairwell is faster than you would, or shorter than you would. You may not be going down as much, but your travel for when somebody's trying to get out of their apartment
Spread out.
will be a shorter walk in conditions, whether they're smoke or not. And so I understand their concerns. I'm glad the firemen are here to protect me, but I can tell you that I won't let my local fire marshal design my buildings, because they are safety first all the time. And in this case, we think there's a balance to it. And that the balance is that, okay, out of your travel distance, you're actually going up and down stairs as opposed to walking down the hall. And we think that's a fair trade-off that local governments can see if they consider and believe like we do.
So the local county or city government would decide whether or not they allowed this then.
Chairman Vaughn.
Yes, ma'am.
Okay, great. Thank you.
Representative Burkhart, you recognize.
Thank you, Chairman. And I appreciate the bill, because where I'm from and Speaker Johnson, they're not as inclined to participate, but there is, if you want sewer there, you need to do this, this, and this. And that cost can run up to $500 to $1 million on a project. And so to get that money recouped is really good for development. And again, if we're going to talk about affordable housing and we're going to talk about it, we've got to do all the steps that do that. So, and it doesn't have to be cash. It could be in the form of credits for tap fees, meter boxes. It doesn't have to be cash. It could, if a district doesn't have, abundance of cash, they can do it in other ways. So anyway, I appreciate the bill, and as far as the fire part of it, it's permissive, and I think that's great, and I'll be supporting your bill, and I appreciate it.
Chairman Vaughn. You got anything?
Thank you, sir.
Chairman Zachary, you recognize.
Question on the bill.
Question's been called. Members, without objection, we are voting on House Bill 2925 as amended to send it to full commerce. All in favor say aye. All opposed say no. The ayes have it. If you'd like your no's to be documented, just tell the clerk. And sir, we'll see you in full commerce next week. Members, that brings us to the end of the calendar, to the hill of the calendar. And so we will take up the special calendar. And that brings us to item number 1, and that's House Bill 682 by Chairman Powers. We have a motion. We have a second. Chairman Powers, you are recognized, and I do show an amendment.
Yes, I have amendment 015893 that makes the bill.
That's what I'm showing as well. We have a motion on the amendment. And I'll take that as a second. We have a second on the amendment. So members, let's go ahead and put that amendment on there. That's drafting code 15893. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended and you're recognized for explanation.
Thank you, Mr. Chairman. House Bill 682 designates the social media platforms as common carriers and requires the entities to obtain certificates of public convenience and necessity from the Tennessee Public Utility Commission, or hereby known as TPUC, by January the 1st, 2025, and for each year thereafter. It requires TPUC to prescribe the rule, the form, and the fee for the certificate application, requires social media platform operators to file certain information as part of the application for their certificate. And I know most of us have been blocked or shadow banned or deplatformed, and this bill will establish that social media platforms may not intentionally deplatform or shadow ban a user based on political ideology, viewpoint discrimination, or discrimination because of race, creed, color, religion, sex, age, or natural origin, and authorizes TPUC to investigate suspected violations and conduct these contested case hearings, prescribes penalties and fines that TPUC may issue for violations. And upon finding a violation, after a contested case hearing, a user is authorized to bring a private cause of action. And with that, Mr. Chairman, I renew my motion.
Thank you, sponsor, for that explanation. We do have Chairman Vaughn. I've got on the list. Chairman, you recognize.
Thank you, Mr. Chairman. And, sponsor, when this bill was first presented, I thought I understood the analogies with regards to common carriers. And I remember the origin of this bill was the opinion that where Clarence, the dissenting opinion that Justice Thomas wrote. And so then as I started reading back and forth on this, there were things that I agreed with and things that I didn't agree with regards to the way that other courts had used this. And so correct me if I'm wrong, oral arguments have been heard by the Supreme Court on this very subject matter. Is that correct?
Chairman Powers.
That's true. And that was one reason we were, went ahead and put it on a special calendar to delay it because we were trying to look at what the Supreme Court was actually going to do on it. Yeah.
Chairman Vaughn.
Yes.
So what I would like to do with this, because we don't know, the ruling may come out in May or who knows, the way they release them, it may surprise us. I don't want to send this to summer study because it would be killed even if we didn't want to do anything, until next year. But if we could lay this on the clerk's desk, and if something comes out of the Supreme Court in the meantime, we could pick it up and make sure that it addresses however they've ruled on it, to make sure, because if this ball is in the air right now, for us to do something with it, I think is a bit premature. But at the same time, I don't think it's time necessarily to kill the bill either. So if we could lay it on the clerk's desk, and if something comes out of the Supreme Court while we're still here, if you could talk the chairman into reopening the committee, then we could probably pick it up at that time. But if not, then we'll wait till next year, and we'll know what the rules of the road are next year, so we don't guess at it. But that would be I'd like to put that in the form of a motion.
Sounds like a motion. We have a second. Members, without objection, House Bill 682 is back to the clerk's desk.
Thank you. Thank you, Mr. Chairman, committee.
Thank you.
Members, that brings us to item number 2 on the special calendar, and that's House Bill 640 by Representative Bricken. I'm sorry, that's actually going to be Chairman Zachary. Chairman, you are recognized. Do we have a motion or a second? Motion. We have both a motion and a second, and it looks like Chairman Zachary, you have an amendment.
Thank you, Mr. Chairman. Drafting code 15489.
That's what I'm showing. We do have a motion and a second. So members, we're voting to put amendment drafting code 15489 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended and you're recognized for explanation.
Thank you, Mr. Chairman. Members, this amendment will look very familiar to you, as we've already added this to the bill, but we added it to the bill. As you know, based on the emails we received all session, the UCC has caused serious concern among Tennesseans. So we are amending this bill down from 80 pages to 1 sentence, and we're simply changing the definition of deposit account to ensure it does not include a central bank digital currency. Some have asked the difference between this and Representative Burkhart's that we passed this morning. His dealt with the definition of money. This deals with the definition of deposit accounts. And some have asked me where this is in the Senate. It passed unanimously on the Senate floor on Monday. So with that, I'll be glad to answer any questions.
Thank you, Chairman, for that explanation. Members, you heard the explanation. Do we have any questions for the sponsor? If not, we're voting to send House Bill 640 to full commerce. As amended, full commerce. All in favor say aye.
Aye.
All opposed say no. The ayes have it. Sir, we'll see you in full commerce next week.
Thank you, Mr. Chairman.
Members, that brings us to the heel of our special calendar, and that concludes our business for the year. So before we adjourn, I do want to say that I have enjoyed serving as y'all's chairman this year. We want to give some thanks real quick. We want to thank, we've always had Mr. Wayne Hawkins as Sergeant at Arms. He's not with us today. We have Mr. Bobby Trotter. Thank you. Appreciate y'all's work. Lovin Middleton Dunn. Our legislative attorney has done a great job and really enjoyed working with you and just appreciate everything you've done for us, Lovin. We have Adam Bright. Is he back there? Adam, appreciate everything you have done for us as well as our clerk. Jackson Stubblefield, this has been his first year as our research analyst, and appreciate everything he's done, as well as Joey Barnett, my legislative assistant. Appreciate you, Joey. And members, I know some of you are retiring this year. Speaker Johnson and Representative Thompson. Yeah. And the rest of you, hopefully I'll see you back here next year. But it's been a privilege, guys. And without objection, Speaker Marsh, you recognized.
Thank you, Mr. Chairman. I just want to say you've done an excellent job. You've been very prepared and been very fair with all of us. I think we've done a lot of good work. Thank you for your
Thank
help.
you. I appreciate that, Speaker. All right, members, without objection, this meeting is adjourned, subject to the call of the chair.